Judge, the webinar has started.
Thank you. Good afternoon, everyone. It's good to see you. And welcome to the Alternative Dispute Resolution Certification Working Group. And as you heard, the meeting is being recorded. Karen Garcia Vargas is filling in for Angela Marlad and will be assisting us today. Thank you so much, Karen. Would you please take the roll?
Yes, Chair. Armstrong, absent. Coulter,
Here.
Curtis, Curtis absent. Dinkin,
Yes.
Dubau, Dubau absent. Ellis,
Here.
Dr. Getz,
Here.
Higauchi,
Here.
Hodgson,
Here.
Kelly,
Here.
Kopekin,
Here.
Cruz, Cruz absent. Lowe,
Here.
Judge Lucky, Judge Lucky absent. Olivsky,
Here.
Judge Bichon,
Present.
Robertson, Robertson absent. Tuckman,
Here.
Welch,
Here.
Yamchun.
Here.
Thank you, Chair. We have quorum.
Thank you. Next on the agenda is the call for public comment. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. Karen, would you please provide the instructions?
For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now, and State Bar staff will call on you in the order the hands are raised. For those who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then number 9. We will allow 3 minutes for each speaker. The on-screen will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining.
Thank you, Karen. And I see Judge Lucky's hand is up. Is that to tell us that you're present?
Yes, I was here. I joined from the office system and apparently you couldn't see or hear me. So I was here when roll was called and for whatever reason nobody heard me when I said here.
Oh, okay. Thank you. Glad you're here. Um, Karen, are there any members of the public who wish to speak?
Yes, we will go with Maurice. Maurice, you have 3 minutes to talk.
Mute. Okay. Hi, how are you?
Hello, you have 3 minutes for your public comment.
Okay, I'm calling about Senate Bill 574, and the way I read section 6173 small b, the number 2 large b, that bill is going to cover not only people who certify, but members of the California bar. It's the way I read it. And so the only people that will be able to dodge the issue with regard to confidentiality are people like Lee J. Berman, who is not a lawyer and has no particular reason to certify because he's an icon in the field. There's no question that confidentiality encourages candor during mediation. And it seems to me that anything that detracts from our purest current statutory system with regard to confidentiality is going to negatively impact people wanting to come to mediation, people participating in mediation. The avenue of use under this section is only when there is an inquiry with regard to malpractice during a mediation. And then it's up to the bar to interrogate the people who are involved in the mediation. And it seems to me as though those of us in the mediation will be required to respond. Otherwise, we're in contempt. So it's not going to happen often, but it's dangerous, and I'm very much opposed to that section.
Thank you, Mr. Atty.
Okay, we have one other public comment. One moment. Terry Breer, you have 3 minutes to give your public comment. Terry, you want to unmute yourself?
Oh, thank you. I'm concerned that the State Bar will find that many mediators will not seek State Bar certification if proposed Section 6173 is enacted as currently written, because it has, of course, this potential negative impact on mediation confidentiality. The State Bar, I see, has made an effort to recognize the importance of mediation confidentiality in proposed 6173 subsection C, D, E, and F, where it definitely strengthens confidentiality of the procedures, and also in rules 3.1120 and 3.1126 of Appendix L of the complaint procedure rules. However, I think more work is needed for these provisions to find acceptance by the mediation community. Rules 3.1120 and 3.1126 provide that the complaint process is intended to preserve the confidentiality of mediation communications as required by the evidence code sections, but it doesn't provide exactly how this is going to be accomplished, other than to say that complaint procedures must be designed and conducted in a manner that preserves the confidentiality of mediation communications. So we certainly need more details here. Another important consideration is that the remedies for complainants must be solely limited to regulatory remedies. The procedures need to clarify that a complainant is not entitled to any form of monetary relief, fee reimbursement, restitution, or other civil remedies. The certification scheme and Appendix L rules should specifically state that the complaint process is purely regulatory and does not authorize a complainant to receive any other form of relief. This will ensure that mediators will not be called as a witness in future civil proceedings, which was one of the concerns when we enacted Evidence Code 1119. And so such a result would be complete contradiction of mediation confidentiality protections.
Thank you, Terry Breer. Karen, is there anyone else who would like to speak?
There are no more public comments, Chair.
Okay, thank you. We'll move on now to the approval of the minutes from the last meeting. Are there any corrections or modifications to the open session minutes from the meeting of July 14th, 2026? If there are none, may I have a motion and a second?
So moved. Yamshan.
Thank you, Mr. Yamshan. Is there a second?
Sure, I'll do it.
Thank you, Mr. Palevsky. Karen, would you please call the roll?
Yes, Chair. Armstrong? Kotler?
Present. I'm sorry. Yes.
Curtis? Dinkin?
Abstain.
Dubell? Ellis?
Yes.
Dr. Getz? Is that a yes?
Yes, that's a yes.
Higauchi?
Abstain.
Hodgson?
Yes.
Kelly?
Abstain.
Copigan?
Yes.
Cruz? Lowe?
Yes.
Judge Lucky?
Abstain?
Levski,
Yes.
Robertson, Tuckman,
Yes.
Welch,
Yes.
Yamshon,
Yes.
Judge Pichon.
Yes,
The minutes have been adopted.
thank you. Next is the report of the chair. I don't have a report for today. I do want to ask you a question. We've had a couple of comments regarding confidentiality from members of the public, and I want to ask if the group would agree to take Appendix D, which deals with that, in the order that it appears on the agenda rather than taking it up at the very beginning. I do understand that um, many of our members have comments that they would like to make. And I just want to know if you're willing to wait until we arrive at Appendix D as it appears on the agenda to give your comments and to tell us about your feelings regarding it. Would that be okay?
Yes. Yes.
Mr. Kelly, I saw your hand. Was that a yes?
Yes,
Your
Madam Chair.
okay.
I just wanted to get an estimate from leadership and staff about when that might happen if we do defer it until it's on the agenda. Thank you.
Okay. Well, we have E, H, A, F, and then D. Mr. Kelly, if it appears that it is taking too long to have the thorough discussion that you want, you're free to raise to take it out of order. Is
Thank
that
you.
okay? Good. All right. So then the next order of business is the staff report. Does staff have anything to report today?
Thank you, Judge Bichon. I do not.
Nor do I.
Okay. All right, so we'll move on to the business, which is to address the proposed new state bar rules, standards, and policies regarding alternative dispute resolution certification program, the return from informal public comment from the new subgroups, and request for approval of the working group recommendations for submission to the Board of Trustees as appropriate. So Ms. Curtis is not yet present. Would staff like to give a report on the mediation subgroup?
Sure, I'll be happy to do that just very briefly. After some of the comments that were received on the requirements for qualifying mediation, there were commenters who expressed concerns that the 2-hour requirement was problematic, particularly for day of court program mediators. And the working group asked that a subgroup should be formed for that purpose. Dana Curtis was appointed by Judge Bichon as the lead of that subgroup. And I won't list all the members at this time. They've been listed before, but they have met now twice. They met before your last meeting in July, and they met again on this Monday, and they're scheduled to meet again on this Friday, moving forward with discussing the interests that are in play, if you will, with regard to certification of day of court program mediators and the qualification requirements for them. So more to report, not tomorrow, but at the August 20th working group meeting.
I think, thank you so much, Mr. Weiner. I think we need one correction. You said that I was the leader of the subgroup.
Oh, no, I apologize. I meant to say that you had appointed Dana Curtis as the lead of the subgroup, or asked her to serve as the lead.
Okay, thank you.
And she agreed, yes.
All right. So we will now work on the appendices as listed in the agenda as you see it. Ms. Mia Ellis and Alan Weiner will show the text of the appendix, and I will present a summary of the comments, and you are always invited to raise any comments that we received that I did not include. So starting with Appendix E, we had gotten all the way to the very end and we're about to call for a motion to approve, and we lost our quorum. So for the benefit of those people who were not present, I'm going to ask Mr. Weiner if he'll just give us a brief summary of what was decided at the last meeting regarding Appendix E.
Sure. Thank you, Judge Pichon. Hopefully you're seeing Appendix E on my screen or on your screen. I'm attempting to share it. And essentially there was only one revision to the tentative recommendation of the working group as it went out for comment. There were two places where there were alternative staff proposals. The working group decided without a formal vote, but decided that they would like to stick with the working group tentative recommendations. So this document is showing the staff alternative recommendations being deleted because they're not part of the working group's recommendation at this point in time. The other change that was made was to a footnote. And again, this was not voted on. These were sort of informal discussions leading up to a vote. And it was a clarification to footnote 3 to say that this provision sets forth a confidentiality obligation on the part of the provider organization and not on the parties. Also, that it is not intended to prohibit the release of aggregate or anonymized information. So that was really the only change that members requested at the last working group meeting.
Mr. Weiner, would you make the print a little bit bigger?
Yes.
Thank you. Are there any questions about what occurred with respect to Appendix E at the last meeting? All right, may I have a motion to approve Appendix E?
I'll make that motion.
And Mr. Pileski? Thank
Yes.
you. And is there a second?
Lucky, I'll second.
Who's that? Who was the second?
I think Judge Lucky spoke first.
Oh, Dr. Lucky. Okay, thank you.
I didn't want to step on Mr. Yamshawn. I'm sorry.
It's a way I can take it.
Sharon, would you please take the roll?
Yes.
Judge Pichon, if I can, I'd just like to display the proposed resolution as I understand it would be.
Yes, thank you.
I'll just put that on the top of the appendix. And this would actually be as amended during the July 14th.
All right, so let's see, Mr. Pileski, would it be your motion to approve the resolution for Appendix E?
That's my motion. Yes, indeed.
Thank you. And Judge Lucky?
Yes.
Okay, thank you. Karen, would you please take the roll?
Yes, Chair. Armstrong, Coulter,
Yes.
Curtis, Dinkin,
Yes.
Duval, Ellis,
Abstain.
Dr. Getz,
Yes.
Higauchi,
Abstain.
Hodgson,
Yes.
Kelly,
Abstain?
Hopagan,
Abstain.
Cruz, Lowe,
Abstain.
Judge Lucky,
Yes.
Polivsky,
Yes.
Robertson, Tookman,
Abstain.
Welch,
Yes.
Yamsh, yes. Yamshawn,
Yes.
Judge Pichon.
Yes,
Thank you. The motion carries.
thank you. Next, we'll move on to Appendix H. And I'll do as I did previously, and that's to tell you what the comments are. And for each section, I'll just ask if there are any changes that you would like to make. And we'll take a vote at the end on the entire appendix. For Appendix H, it's the tier structure for provider organizations. 3 organizations took a position or submitted narrative comments. There were 17 narrative comments, and there are 15 tiers criteria. For criteria number 1, there was no comment. For criteria number 2, there was no comment. For criteria number 3, the comment was unacceptable as a provider, let me see, unacceptable to as that a provider provide training to a non-member for free. That was the comment for number 3. On that, does the group wish to make any changes to number 3, criteria number 3?
Number 3 doesn't say anything about that.
You know, I didn't, for the comments that were brief, I gave them as they were placed. And that was the one comment. Okay, criteria number 4, the comment was, how does a provider organization require compliance? Requirements for a provider organization to ensure compliance should be detailed. That was the only comment. Would the group like to make any changes? We'll move on to criteria number 5. There was no comment. Criteria number 6, the comment was, this is burdensome for a community mediation program that onboards volunteer mediators regularly to offer ethics training each month. Also burdensome to mediators who join several panels within a 2-year period. The other comment, essential for a grace period after a panelist becomes affiliated with a provider. Those were the comments for criteria number 6. Would you like to make any changes? Moving on to criteria number 7. The comments were, ethics training should not be every year. Attorneys can complete their ethics training every 3 years. The other comment, training provided by organizations other than the State Bar should be allowed. If not, then the burden of monitoring should be on the State Bar. Would the group like to make any comments on criteria numbers, any changes on criteria number 7? Criteria number 8, the comments were the same. Does the group wish to make any changes to criteria number 8? Criteria number 9. It may be challenging to develop this training and provide it every year. Oh, provided live every year. Would the group like to make any changes to criteria number 9? Criteria number 10, no comment, no narrative comment. 11, no narrative comment. Criteria number 12, the comment is, it is burdensome to require community mediation programs to be required to offer this training to the general public at no cost. Then other comment was, should be able to charge non-members but exempt volunteers. Would the working group like to make any changes to criteria number 12?
Again, this doesn't talk about that. Are we looking? Number 12 here talks about website information. It's so interesting.
I know. I agree with you. Criteria number 13, the Narrative comment is it the intent to require surveys for both attorneys and parties? Does the group wish to make any changes based on that comment or for any other reason? Criteria number 14, no narrative comments. And for criteria number 15, the comment is requirement that an organization, all California-based panelists on its website, is a significant burden on larger provider organizations. Would the group like to make any changes? If not, it looks like Appendix H will stand as it's written if the group agrees.
Judge Pishon?
Yes.
Yeah, if I may.
Go ahead. I was just
on,
for the resolution.
Yeah, but before that, in discussion of another appendix that kind of baseline criteria for provider organizations, the working group discussed whether or not to retain the bracketed text California-based, or whether to delete the text in the brackets or to delete just the brackets. And the decision was to delete the bracketed text. To delete the bracket and retain the text. So I think to be consistent with that decision, the brackets should be removed throughout this appendix. And I just ask if the chair and working group members agree with that recollection and approach.
Sure.
Is there any objection to that, Dr. Getz?
No, I wasn't on that issue, but thank you. No objection to that.
Are there any objections to that? I don't see any hands. Okay, Dr. Getz?
Thank you, Judge Pishon. I noticed a couple other comments that, I just bring up for interest of the entire working group that were in the public comments. I think it was mostly on the training, number 3, number 9, and number 15, that some panels objected to the fact that if they offered the training at no charge, and these were community mediation panels and also arbitration panels, that they should be able to charge a fee to other participants who weren't part of their panels. Again, I just bring it up in the interest of complete disclosure about the public comment that I saw.
Thank you. Would the group like to make any changes based on that information? All right. Mr. Weiner, would you please put up the resolution?
So the proposed resolution would be resolved that following notice and publication for informal public comment, the Alternative Dispute Resolution Working Group approves and recommends that the Board of Trustees adopt the Alternative Dispute Resolution Certification Program recommendations published for comment as Appendix H. And this would be as amended during the working group meeting. And the only amendments would be deleting the brackets surrounding California-based, which I'm in the process of trying to do and can continue doing while roll is taken, if there's a motion in a second.
All right. And the resolution was up at the top?
Yes.
All right. That is the resolution. Is anyone willing to make a motion to approve Appendix H?
If no one else wants to.
Okay. And that was Mr. Plesky?
Yes.
Okay, thank you. Is there a second?
A second.
And Was that Mr. Yamcha?
Dr. Getz.
Oh, Dr. Getz?
Yes.
Thank you. Karen, would you please take the roll?
Yes, Chair. Armstrong, Coulter,
Yes.
Curtis, Deacon,
Yes.
Dubow, Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi,
Yes.
Hodgson,
Yes.
Kelly,
Abstain.
Copigan,
Yes.
Cruz, Lowe,
Abstain.
Judge Lucky,
Yes.
Lipsky,
Yes.
Robertson, Tuckman,
Abstain.
Welch,
Yes.
Yamshon,
Yes.
Judge Bichon.
Yes,
Thank you. The motion carries.
thank you. We'll move on now to Appendix A, and that's qualification requirements. You received an executive summary regarding the workings of the arbitrator qualifications subgroup 2. I hope that you've all had the opportunity to read through it. It is extremely comprehensive and thorough. Staff did a great job. That's Mr. Weiner, Ms. Ellis, and summarizing what occurred in the subgroup and what the recommendations are. We have already gone through the entirety of Appendix A, except for the two things that are listed in red, and that is the qualifying arbitrations and also it was qualifying arbitrations and the definition of, I believe, qualifying arbitrations. And then there's one other change on qualifying arbitrations. I'm going to ask Mr. Weiner if he'll fill in a little bit regarding the workings of that subgroup, or Ms. Mia Ellis.
So I think Dr. Getz may be prepared to summarize the work of that subgroup, which he served as the lead of, or he may have asked members of the subgroup to do that. I'm happy as well to do it, but I don't want to step on toes of those who have maybe been planning to.
Well, why don't we do it this way? If this is okay with Judge Bashan, I'll just introduce it. I think, Mr. Weiner, you can show what the changes are that were made, and then we can have members of the subgroup explain it further. So basically, the subgroup that was formed was to look at the public comments. There were two major areas in which there were public comments. One is whether or not we should establish a judicial track that's separate and apart in training requirements and continuing education requirements for someone as an arbitrator who served as a prior bench officer. We got some public comments on that. And then secondly, the definition of qualifying arbitration. As you recall from our initial meeting about this, the majority of people who commented publicly did not agree with the definition of qualifying arbitration. So we were to look at that. And again, there weren't a lot of people. I don't want to go overboard in that, but it was the majority of people commented that wished us to change it to some degree. So, if it's okay with you, Mr. Weiner, I'd maybe like to introduce a member of the subgroup, have Judge Lucky perhaps talk about the judicial track first, and then we can get to some of the changes on the qualifying arbitration. Would that be okay with you, Mr. Weiner?
Certainly. Thank you, Dr. Getz.
All right. So Judge Lucky, I know you participated in the consensus on the judicial track, looking at those comments. Would you care to talk about our work and where we concluded on this?
Yes, and I was on the original arbitration committee that developed the original text. And I'm sorry for coughing. And then on this subgroup that took up the question of whether we should revise it. And in both, as a retired judge who does arbitrations, I advocated for not creating an exception for judges. And I think the reason is simple. They are related but distinct domains, just as lawyering and judging are distinct domains. In judicial education, when we switch assignments to new areas, we get a new 40-hour course called a primary assignment orientation, where we learn the subject matter of what we do, because the Judicial Council and I think judges writ large understand that when you enter a new domain that has different procedures, possibly different substantive law that applies, that one should be trained in that domain. And although at a superficial level, we're dealing with things that are similar, a neutral taking evidence and then rendering a decision. Judges are constrained by the Constitution and the law. They are not generally constrained by contractual limitations on their power, and they don't generally have different statutory schemes that define their power in different ways. All of those things are true with arbitration. Discovery is not only limited in a practical sense in arbitration, but the jurisdiction to order discovery can be very different for an arbitrator than it is for a judge. And so I think that when we make this transition as retired judges, we need to recognize that we are in a similar but distinct role. There are going to be similar but distinct rules. And for that reason, we need similar but distinct training. So I'll try not to belabor the point and stop there.
Thank you, Judge Lucky. The group also reached a consensus on the definition of qualifying arbitration with some edits and some disagreement in the group, which we can talk about later. But first, I'd like to let Mr. Weiner describe the edits that we made in the definition of qualifying arbitration. Mr. Weiner?
Thank you. So the definition is really just changing 3 words. Hopefully you're seeing this on my screen. But in the proposed definition, new definition of this new subgroup would be qualifying arbitrations must include a contested hearing with at least 2 hours of live testimony and authoring a reasoned written award, which may be an interim, partial, or final award. So really the proposed change from the working group's tentative recommendation that went out for comment would be to change that the arbitration must result in a reasoned award to authoring a reasoned written award. Dr. Getz, do you want me to explain the reason for that, or would you like to speak to that since it was based on one of your comments?
Either way, but I can just explain the reasoning is I participated on panels where the chair was largely responsible for authoring a reasoned written award. So if the purpose of this is to ensure someone has experience with writing a written award, a reasoned written award, then the other panelists may not have contributed at all. They certainly have the opportunity, but they often may not participate. So this sets it up so that the person who actually did the work is actually part of the qualifying arbitration standard. I think that was the general reason behind that. We had another change as well, didn't we, Mr. Weiner, on this?
I don't think we had a change to the definition, but we had changes to the quantity of qualifying arbitrations. Is that what you're thinking of, or have I missed something?
That's exactly what I was thinking of.
Right. So as the working group's tentative recommendation was distributed for public comment, it would have required at least 3 qualifying arbitrations. So this incorporating that definition. Many of the comments that Dr. Getz mentioned and discussion on among the subgroup was that in the current arbitration market, an arbitrator may conduct many arbitrations without having arbitrations that result in a reasoned written award, because the parties may settle or because the parties may request not to have a written award, or perhaps for other reasons. So the concern was that it would have been hard for some arbitrators to satisfy the requirement of 3 qualifying arbitrations. The subgroup, although understood that the intention of the 3 qualifying arbitration requirements for both Path 1 and Path 2 was that those would need to have been within the 3 years prior to applying for certification. So the first clarification the subgroup is proposing is to say that those 3 qualifying arbitrations must occur within a stated time frame. I think the belief was that the intent was to require those within 2 years prior to applying for certification, rather than for 3 years. When the working group discussed other provisions of the qualification requirements, it changed other periods of time from 2 years prior to applying for certification to 3 years prior to applying for certification. So, for example, the requirement to complete the specified training. This new subgroup is proposing that the 3 qualifying arbitrations have been completed within 3 years prior to applying for certification. And it also is adding, another alternative, or at least 5 qualifying arbitrations within the 5 years prior to applying for certification. And it would be the same change that's being proposed with regard to both Path 1 and Path 2. And the reason for adding this additional option of 5 qualifying arbitrations within 5 years prior to applying for certification was that it was noted that some arbitrators may have no qualifying arbitrations in a year or in 2 years, but if that experience requirement was extended to 5 years, then there would be a greater likelihood that they might satisfy the requirement. So that's my, if you will, summary of why the working group made those changes.
Thank you, Mr. Weiner. And Ms. Lowe, I know I said that you would have an opportunity to introduce this. I don't know if you have additional things or additional comments you want to make from the subgroup discussion about either the changes that Mr. Weiner went over.
Thank you. No, thank you, Dr. Katz. I think Alan did an incredible job covering it, and I think the report was very comprehensive, so I don't want to belabor any of the points. I think that's a very accurate description of the discussions that we had.
Thank you. Thank you so much. All right. Well, as then Judge Bashan, as I mentioned before, there was one minority opinion on the subgroup. So I was not part of the original group that came up with the recommendation. But in processing the public comments, I was allowed to bring some of those in and also add my own thoughts. And I'd like to spend just a couple of minutes discussing that so that if others have a reason to opine, we can go through that. So yes, Mr. Weiner, if you can go up to the definition of qualifying arbitration again. All right. So my minority opinion is this. We are a consumer protection statute. We're in that. We have chosen with this definition, maybe not intentionally, to provide the minimum amount of public protection that is possible under the statute. And it's really just a matter of math. I know some of you are not as involved in arbitration as others, so let me just take a second to lay it out. Mr. Tuckman, and I didn't know you were not part of American Arbitration Association, but I did go to the site, and it makes it clear that 70 to 75% of all arbitrations are resolved prior to a hearing. Now, I went to some other sites as well. Some think it's as high as 85%, but at least for now, because the math doesn't really change a lot. Let's just go with the American Arbitration Association. Let's say it's 70%. That means 70% of scheduled arbitrations are concluded before there's ever award time. Okay, so that means 70% of consumers involved or participants in arbitration are part of an arbitration proceeding in which lots of things are happening, but it's not an award. It could be that settlement's going on. It could be motion practice. In fact, as an arbitrator, I've spent double the amount of hours in motion practice this year as I've spent in hearing. There's discovery motions, there's motions to compel, there's all sorts of things that you have to handle. In fact, many consumers who pick arbitrators are very well schooled in how fair they are in these proceedings. If they have attorneys working on their behalf, they're looking over how quickly they move the proceeding. They're not really looking through the prior reasoned written award. So 70%, if we buy the American Arbitration Association statistic, basically conclude without a reasoned written award. Now, of the remaining 30%, how many actually have a reasoned written award? I would tell you there was no statistics I could find online, and I'm not the working group's expert on this. I would say it's a small fraction, but even if it were 50%, let's say that takes it down to 15% actually might have a reasoned written award. So 85% of the time, arbitrators are involved in a lot of things that have nothing to do with our qualifying arbitration definition. So it produces a result in which most disputants, as they look at arbitration, are not really protected by our standard for qualifying arbitrations. It affects a very small subset of those arbitrations that are scheduled. It produces anomalous results. So I've participated in two types of arbitration panels primarily. One is with FINRA, in which you have arbitrators picked through a ranking and list selection process. And one is through the LA County Bar, where I do attorney-client fee arbitrations. Attorney-client fee arbitrations, you are basically selected. And the disputants don't have a choice, unlike FINRA, in who sits in on their arbitration. Now, the LA County Bar arbitrations, they have no discovery motions at all. But they do have reasoned awards. But whereas at FINRA, we process a lot of motions, and we do not generally have reasoned written awards unless the parties request it, which they can, and which they can also in most arbitrations. They can, although many attorneys opt not to request a written award. So my point is that we are now putting in place a standard in the marketplace that doesn't exist. Those that participate in a voluntary pro bono panel for the LA County Bar Association will have an opportunity to participate in a qualifying arbitration, and those who participate in a selective environment in which you have securities attorneys picking through arbitrators and selecting them, participate in a lot of stuff, often will not make this qualifying arbitration. That is not a kind of certification the marketplace would respect. I think it will actually lower the feeling in the marketplace about our certification. So it affects very few people. I would add additional two components, I'm also sensitive to the fact that staff might maintain, well, someone could go volunteer, like in FINRA could go volunteer for authoring some awards. And yes, but I don't think that's the ideal way to create volunteer services, by sort of creating a certification that they can only qualify by volunteering in another environment. But we'll put that aside for a second. This creates perverse incentives for our certified arbitrators or would-be certified arbitrators. One, there's a disincentive to encourage settlement, because the only way you can get to certification is actually if there's a hearing. So you don't want, not that anybody would do this. I'm not saying that my colleagues would do it, but I wouldn't say my colleagues would do what Tom Girardi did either. But I would just say this, that it creates an incentive, one, not to encourage settlement, and two, to encourage the parties to ask for a written award. In some environments, that encourages the parties to pay extra for a written award. So it creates these perverse incentives, which I agree with the group that we hope that nobody would actually act on those incentives, but I'd rather not create them in the first place. So I'm going to conclude my remarks and then hope there's some discussion about this. But the reason I can't vote with the consensus on this is I believe it establishes a standard in the marketplace that's not recognized and would not be respected. Number two, it does the minimum amount of consumer protection because most consumers who participate in a arbitration process don't get to a reasoned written award. And then it has also the perverse incentive. So I think we would attract very few arbitrators of the field. So we have a chance here to set a certification that honors the field and yet we've created, in a way, our own poison pill, as it were, to make sure that most arbitrators would not qualify for this. I've had my piece. Thank you, Judge Prashant. Thank you, working group. I hope I at least given you some food for thought.
Thank you, Dr. Getz. Thank you, Judge Lucky. Thank you, Mr. Weiner. Mr. Yamshana, I see your hand. I just want to make it clear or to clarify whether the alternative staff recommendation in path 1 and path 2 still exists. Is that still out there?
Yes, Judge Bashan is potentially still out there. It may be withdrawn before there's a recommendation to the Board of Trustees. It may depend on what the working group decides with regard to the definitions of qualifying arbitration, but staff will certainly reconsider that recommendation in light of the comments that have been received.
Okay, all right. Mr. Yamshan.
Thank you, Judge Bashan. I agree with Dr. Getz in his conclusions. I don't think that it would necessarily create disincentives to settle, assuming that we have honest arbitrators, and most providers do a very good job in vetting their arbitrators. But in my experience, it's very, very rare that parties want a reasoned award, and there's various reasons for that. I wasn't part of the second arbitrator working group, but I was part of the first arbitration subgroup. Counsel simply oftentimes don't want to pay the arbitrator the extra money involved with the reasoned award. They may want one if they think that they may need a reason to explain to their client why they didn't prevail. But even then, they can usually have the ability to deal with their client. The other reason is that a reasoned award generally will do them no good. You cannot appeal an award where the arbitration clause calls for final and binding arbitration. There's 4 grounds in the Federal Arbitration Act and in the equivalent state act. Mistake of laws won't be grounds. Manifest disregard of the law is not a ground under the Hall Street case. So there's no incentive for counsel to want a reasoned award. And in fact, the incentive, in my experience, even with large, very complex multi-party cases, is counsel specifically tell the arbitrator during the initial pre-hearing conference that they do not want a reasoned award. So in terms of outcomes, I think Dr. Getz is right, is to require reasoned awards will basically, as he put it, insert a poison pill into the process. Thank you.
Thank you. Mr. Tuckman?
Thank you. Just a couple of thoughts. First of all, so uh, I was with the AAA for a couple decades, actually more. And although I left last year, obviously my thoughts are very much informed by that work. And I uh, ran the legal department, but I also, throughout various points in my career, ran operational offices, the International Center, or parts of the organization that were administering arbitrations. I guess I do want to at least clarify from my perspective, in terms, it is true, there's no question that very large numbers of cases that are filed, at least I'm just talking about the AAA, but there's broad array of case types. Many do not go to an award. That is absolutely true. They're settled at a rate less than you might see in the litigation context, but large numbers settle. The last numbers I saw for business to business disputes, these are commercial disputes, it was more around 50% of cases settled prior to an award. That's my recollection. Something like, I think, 35 or 40% settled before any arbitrator compensation. So I do, other cases are very different. Employment, for example, a much larger percentage of those cases do settle before an award. So there are variations, but I'm just using the commercial business to business disputes as an example. So I do think it's a larger number of cases actually that do go to a final award. The other point I want to make is that the definition as it exists now allows a reasoned written award, which can be interim, partial, or final. There's a lot of stages along the way. And in many cases that don't go to a final award, there are these interim awards, there are partial awards, and those still count. I believe that when we put this all together, I'm just a little bit more persuaded by, if somebody is certified by the California State Bar, there's going to be a presumption that that arbitrator, that individual, can write an award, that they got some experience doing it, and some substantial experience doing it. So I have a slightly different view, and I just wanted to share that again based on at least the statistics that I recall and remember and my experiences.
Thank you, Mr. Tuckman. Mr. Palevsky?
I was part of this group and with the consensus. Just a couple things. I would be very interested in knowing whether Dr. Getz has a suggested alternative, because I think part of the problems we all had from the very beginning of this is coming up with a better solution to all of the competing interests. But it's been my experience that most cases do settle, and I don't want this to be such a barrier. But I also understand not only the staff's desire to have the certification mean something, and I can tell you from a plaintiff standpoint that there is an emotional component to at least the work that I do. And losing a case without any explanation is devastating. And there's an emotional need to at least understand, even if you disagree with the solution. It's really important to at least understand. I would point out that there's no definition to reasoned. So I don't think it necessarily requires a 30-page written decision. So I'm with the consensus, but I'm curious as if there's a better solution to address Dr. Getz's concerns, because I think they're valid.
Mr. Yamshan? Thank you, Mr. Palevsky. Mr. Yamshan?
Thank you. I just want to be clear. I'm not offended or against requiring a written award. It's the reasoned award that bothers me. And I don't want to rehash the reasons. But I could certainly live with requiring a written award, which can be interim, partial, or final.
Thank you. Dr. Getz?
Yeah, I'm just answering the question. One of the public comments was that we base it on hours in arbitration, very similar to the direction we were going, but I know we haven't quite concluded on in mediation. If we wanted to do a more elevated level, certainly talking about spending hours in motion hearings would be the next level up. At least more arbitrations go through that process than go through a written reasoned award process. But the first level, I think, would be hours in arbitration. That's similar to where we are with, at least our initial thinking was with mediation.
Thank you, Dr. Getz. Mr. Weiner?
I'd like to yield to Mr. Kelly first. I do have some thoughts I'd like to share after members of the working group have finished doing it.
Mr. Kelly?
You're muted.
You're muted.
Just quickly, in the interests of time, I taught arbitration for quite a while through the bar associations. I've been an arbitrator for 30 years. My experience was the same as Mr. Polewski is talking about. I got advice a long time ago, which is the award's for the winner and the reasoning is for the loser. And I think there is a lot of value to being able to write a reasoned award so that the loser gets why they lost. That's all.
Thank you, Mr. Kelly. Mr. Weiner, do you want to go next?
I'll yield to Judge Lucky, if I may.
Judge Lucky?
I will try to keep it brief. I think this is something that I always tell folks about judges having to make decisions and what the law does to parties, which is we have a one-size-fits-all solution to employment arbitrations and commercial arbitrations. That's the situation that this statute has created. And I think the Supreme Court has told us we need to have reasoned awards in fee-high employment cases. And I agree with everything that Mr. Polewski and Mr. Kelly said about the reasons why. I think the difficulty is we've struggled with this definition for so long. I'm not saying we've done a great job. I'm saying we've come up with the best one-size-fits-all solution that we can with these competing interests. I would love if someone smarter than I and the groups with whom I've worked could come up with a better definition. One of the observations that I made was I think 2 years ago, it would be very easy for me on the previous definition to become a certified arbitrator. In the past couple of years, I don't know if it's me, the market, or whatever it is, the volume of my cases hasn't gone down, but the number of arbitrations that have made it to hearing have plummeted in the past couple of years. And there's nothing that we do as arbitrators, I shouldn't say nothing, but there's little that we're going to do as arbitrators to affect that. And I hope that, as Dr. Getz said, the better side of ourselves will come out and not try to push things to a hearing just so we can get the tick mark that we need to become certified. I don't know, candidly, whether there is a definition that we can come up with that is going to be acceptable, because I think that when we're dealing with large companies who are dealing in an arm's length transaction, who choose arbitration and are maybe not as concerned with the consumer protection aspects of it, they're looking for something different. And when we're dealing with a client like Mr. Polewski has, Mr. Polewski and I will always agree to disagree on what it means to be compelled to arbitration. But I still think that the interest for the employee there, as defined by the Supreme Court, is to have some assurance in a consumer context to know this arbitrator that I'm getting, and at least my feeling is not directly by my choice, is somebody who has done the job and somebody who I can verify has done the job at some point in time.
Thank you, Judge Lucky. Mr. Weiner.
Thanks. I'll just Judge Lucky said most of what I was going to say. I think it was really his anecdotal experience on the number of cases that have settled recently versus those that have gone to award that I think resulted in the subgroup adding the 5 within 5 year approach to it. I also want to underscore my view from a public protection standpoint. As Judge Lucky and another member said, it's important, I think, that people who select a certified arbitrator know that the arbitrator has experience with the complete process leading up to a written reasoned award. I would have a concern about taking out the reasoned part because otherwise a written award might just say claimant takes nothing or claimant takes X amount of dollars. So those are my thoughts.
Thank you, Mr. Weiner. Dr. Getz?
I don't have much more to add except to remind everybody that we require as part of the training to become a certified arbitrator that you go through training on how to write a reasoned award. So this does show a little bit of lack of trust in our training requirement. So decision and award drafting, as you might recall, we tentatively approved, I believe, or approved in full. I would think that we should rely upon that, understand that most arbitration processes do not really, it's not going to be much of a protection of consumers if we just wait to a reasoned written award and understand that we're looking at a limited pool of arbitrators who might qualify. Thank you.
Thank you, Dr. Getz. I don't see any other hands. Okay. Great discussion. Now,
I see Mr. Polevsky's hand now.
Mr. Gillespie, I'm sorry.
This is very brief, but there are certain categories of cases where a lot of cases settle. Maybe a solution is for arbitrators who aren't doing those kinds of cases to either volunteer for the Bar Association or do other kinds of arbitration work, community arbitration work, where they will have more opportunity to satisfy what seemed to be a fairly low bar. And finally, is I don't really think that Judge Lucky and I will ultimately disagree on what it's like to be compelled to waive your constitutional rights, but we'll talk about that separately.
Thank you, Mr. Polevsky. All right, so out for discussion, we have the subgroups recommendations, and they're in green on your screen, that's the green writing. We also have the alternative staff recommendation, which you see is at least 6 qualifying arbitrations in Path 1 and Path 2. And then we also have the position just described to us by Dr. Getz. I need to know how to proceed if someone asks if I can take a straw vote on which of these procedures we like to, or recommendations you'd like to pursue. We can do a straw vote and narrow it down to the one for which Mr. Weiner will prepare a resolution. How does that sound?
That sounds good. Could you scroll back up to the ones up? All right, thank you. Is there a way to get the 3 alternatives on the screen at once?
Yes.
Thank you.
Not immediately.
We're neutrals. We're patient people.
When you say the 3 alternatives, do you mean the 3 places where there are changes that have been proposed by the subgroup?
Yes, thank you.
So I'm going to give you 2 of them. The one for the requirements for qualifying arbitrations for Path 1 and Path 2 would be the same changes, but let me show you what I think you're asking for. So this is the subgroup's recommendation regarding for path 1 and path 2. I think the working group can disregard the alternative staff recommendation unless there's somebody who's inclined to move that be adopted. And then this would be the proposed change to the tentative recommendation regarding the definition of qualifying arbitrations. Does that give you what you're looking for, Mr. Yamshan?
Yes, thank you. So, Judge Pishon, if I may ask, the straw poll, were you looking to see how many people would prefer the first of the alternatives that we see or the second one, or how would you approach that?
So I think staff has now said through Mr. Weiner that they will drop their alternative recommendation. Did I hear that correctly?
Well, I said that we would reserve that, but I think for purposes of the working group's discussion, unless somebody has been convinced that there should be more, I think that could be off the table as far as the straw poll for the working group recommendations. I could see that, for example, if the definition of qualifying arbitrations were to significantly change, that might change the staff perspective on its alternative recommendation.
Oh, great. Thank you. So what I'll do is just ask regarding the alternative staff recommendation, that is at least 6 qualifying arbitrations. Would anyone of our group be willing to move that forward? If I don't see any support for it, then we will drop it. So is there anyone who would take the position that they would like to have that recommendation? Okay. Okay, I don't see any hands, and please let me know if I'm missing any. Okay, so then for path 1 and path 2, the staff alternative recommendation comes off. So now what we have left, and the question was, is it these two? Yes, it's these two I would take as one. The second is the recommendation by Dr. Getz. So,
Okay, I'm sorry, I'm confused.
yeah. Okay, I don't blame you. So what I'm saying is the subgroup's recommendation consists of paths 1 and 2 and the language in green, and qualifying arbitrations, the word authoring.
Right. Okay.
That would be,
So
okay, go
if
ahead.
we can accept, I don't think there's going to be much argument about the first one that's shown, that they require at least 3 qualifying arbitrations within 3 years, 5 within 5. I think where the group is going to have an issue is with the definition that it would include authoring a reasoned award. And then how do we deal with some of us not being against requiring the arbitration go to a written award, but have problems with the reasoned written award?
Okay, we can take it separately. I can just ask, we need to put that under Dr. that it must include a contested hearing with at least 2 hours of live testimony, and that would be the end. And Mr. Yamshan must include a contested hearing with at least 2 hours of live testimony without the reasoned award. So,
Okay, it should include a written award, but it doesn't have to be a reasoned award.
okay.
You may just bear with me just a minute. I'm trying to capture this, what I'm understanding. This is not crossed out, and this is crossed out. Mr. Yamshan, is this what you're asking about?
Yes, thank you very much.
Okay, and I see Dr. Getz has his hand up. I don't know if there's a correction to what I've characterized as your proposal, Dr. Getz?
Yeah, this isn't my proposal. I like it better than where we were going, but it doesn't honor the fact that most arbitrators spend much more time in motion practice, which are contested hearings, but it's not necessarily live testimony. So my actual belief would be, so I'm okay with living at this, but I wouldn't put Dr. Getz next to it.
Well,
So
I'm trying to capture what you want, because I think that Judge Bashan
what
wants everybody to consider all of the proposals. So,
mine would be a much more elaborate um, definition, which say to qualify as an arbitrator, you must have had at least X hours in contested hearings over a 2-year period, or however you want to put it. That'd be much more where I'd be going.
Okay, so this is what I had planned to do when I talked about the positions. Dr. Getz's, I would not try to summarize because he said it so eloquently. I would just put the position stated by Dr. Getz, and if it's okay with the group, I would ask, um, this is a straw vote time. Would anyone be making a proposal to accept the recommendation or the by Dr. Getz? And if not, then we go to the other two and ask.
Well, I will support my recommendation, but I'm not sure you were looking for that.
Well, yes, I was. Okay, is there anyone else who would support moving the proposal of Dr. Getz forward?
I see Miss Coulter's hand.
Ms. Coulter?
I don't know if it's to
Coulter and
speak or
Welch.
in support.
Ms. Coulter? Yes. Was your hand up? I'm sorry. Please go ahead.
No, I'm just saying, yes, I would support Dr. Getz's proposal, moving that forward. And
All
I
right.
think Mr. Welch is in support of that as well.
Thank you. All right. That's 3. Anyone else? Okay, I don't see any other hands. So that tells me that the group does not want to put this proposal forward. Okay. The next one, and I think for Mr. Palevsky, I'll take them one at a time. The path 1 and path 2, the 3 years prior to applying for certification, or at least 5 qualifying arbitrations within the 5 years prior to applying for certification. How many in the group would support this going forward for paths 1 and paths 2? Okay, so
Right.
3. No? 4?
I see quite a few more than 4. I see Mr. Kelly, Mr. Yamshan, people are moving around. Judge Lucky, Mr. Tuckman,
Okay.
Mr. Welch, Mr. Palevsky, Mr. Dinkin.
Okay. So that means that we will keep for paths 1 and path 2, we'll keep the language in green, that's written in green, for the resolution that will be prepared by Mr. Weiner. Now, the next one would be the subgroup's recommendation regarding qualifying arbitrations must include a contested hearing with at least 2 hours of live testimony and authoring a reasoned written award, which may be interim, partial, or final. Would any members of the group propose moving this one forward? How many would support this one?
Miss Ellis, can you help with the counting? My screen isn't
Yeah, it's moving
cooperating.
around when people raise their hand, but I see 4.
4. Okay, that's not quite a quorum. So then we'll move on to the proposal that it's under Mr. Yamshan's name, that the qualifying arbitration must include a contested hearing with at least 2 hours of live testimony and authoring a written award, which may be interim, partial, or final, and it takes out the word reasoned. How many of the working group would support moving this one forward?
I see Mr. Yamshan's hand. Only so far.
I just see Mr. Yamshan.
All right. So what I'm going to do then is now, please, yeah, I'm going to ask Mr. Weiner if he'll prepare a resolution that incorporates paths 1 and paths 2. I'm sorry, can you put it back?
I'm sorry.
Right.
Give me just one moment and I will put it right back up for you. I'm just getting the resolution ready, and apparently
yes,
it's
I
wanting to
understand.
share the resolution. So let me get back to the Appendix A
Okay.
and share that
All right.
and put it resolution up here.
So the resolution would incorporate path 1 and path 2, the language in green, and it would include authoring qualifying arbitrations. It would include authoring a reasoned written award, etc. That's the resolution that Mr. Weiner is going to prepare for us. Now, if you have any objection to that, please let me know.
All right, may I read this, Judge Bishan?
Yeah.
So I'm noting here that really the only issues being discussed and voted on are the number and definition of qualifying arbitrations, because the rest of Appendix A was approved at a previous meeting.
Okay.
So the proposed resolution is resolved that following notice and publication for informal comment, the Alternative Dispute Resolution Working Group approves and recommends that the Board of Trustees adopt the Alternative Dispute Resolution Certification Program recommendation regarding the number and definition of qualifying arbitrations, published for comment as Appendix A, as amended during the working group's August 5, 2026 meeting.
Is this appendix, this resolution as written, does it support our discussions? Okay. I'm going to then ask if a member of the working group is willing to make a motion.
All right, well, let's move it.
Mr. Gillespie, thank you. Is there a second?
Second, Ms. Kelly.
Thank you. Karen, would you please take the roll?
Yes, Chair. Armstrong? Coulter?
No.
Curtis? Dinkin?
Yes.
Dubow? Ellis? Dr. Getz?
No.
Higuchi?
Abstain.
Hudson?
Yes.
Kelly,
Yes.
Copigan,
Yes.
Cruz, Lowe,
Abstain.
Judge Lucky,
Yes.
Polivsky,
Yes.
Robertson, Tuckman,
Yes.
Welch,
Abstain.
Yamshin,
Yes.
Judge Pichon.
Yes,
Thank you. The motion carries.
thank you, Karen. All right, I think that it's time for us to take a break. Mr. Kelly, do you want to be heard? Otherwise, when we come back from break, we'll take Appendix F.
I would like to be heard, Madam Chair. Thank you.
Okay. You're welcome.
I would appreciate the opportunity to discuss the public comment about the pending legislation and Appendix D when we return from break and see what else can be done with the remainder of the afternoon, if that's acceptable.
Ms. Mia Ellis, do I need a second on that?
No, we're taking it out of, I mean, it's on the agenda, so it's up to you, Judge Pichon. You need a
All right.
second.
Thank you. Yes, when we come back from break at 3:45, we will discuss Appendix D and the public comments regarding it. Okay, so we'll be on break until 3:45.
Thank you, Madam Chair.
You're welcome. All right, welcome back from the break. We will now discuss Appendix D. We had 2 public comments today, and we have a lot of public comments on Appendix D. If we take it in order, we should get to the sections that I believe most people want to discuss if we go in order. However, if you want to take a portion of this out of order, we can do that. So I would go through like standard 1, 2, and under 2, I believe that's where the comments would come. So if it's okay with the group, we can move in order. Mr. Kelly?
Thank you. If it's acceptable to the chair, I'd like to respond initially to the public comments, and that may affect quite a good deal whether I offer any motion to amend D or not.
Okay, go ahead.
Thank you. So for more than 3 decades now, all mediation participants have been able to be candid, knowing that only with their consent could their mediation communications be admitted or disclosed in any later non-criminal proceeding in which California law applied. SB 574's new paragraph 6173 B2B will negate that assurance whenever disputants use state bar certified mediators. If it remains in the bill, that paragraph will require all state bar certified mediators and mediation providers and all attorneys in any mediations they conduct to turn over all requested mediation related communications to state bar investigators or the agents of state bar and their investigators. And this will include all requested information, records, and communications previously protected by our mediation confidentiality statutes, by attorney-client privilege, by attorney work product doctrine, by the attorney's duty to protect client information, or any other law. I believe this will be extremely detrimental to the certification program. I think eliminating predictable protections for mediation communications will significantly reduce the number of mediators and providers applying to become certified. This will significantly reduce funding for the program and/or increase the size of required fees. I believe parties who are informed about this will avoid certified mediators and prefer mediators who can still offer confidential processes protected under our current statutes. I think staff and the public deserve to hear a discussion of the impacts that we believe this legislation will have on the viability of the certification program we've all donated a year of our time attempting to craft. And SB 574 will be amended, killed, or enacted by the end of this month. Ms. Ellis pointed out in her email to us that state bar policy prohibits this working group from advocating on legislation. I read it, I agree with that. But I do believe it'll serve the public interest for there to be a simple straw poll of how many members of this working group believe the legislation as it now reads will have a significant negative impact on the willingness of providers to become certified and the willingness of informed users to use certified mediators. And I respectfully request that we conduct that straw poll now. Thank you.
Thank you, Mr. Kelly. Comments from others? Comments on the okay, yes, Judge Lucky.
I'll make mine quick because I don't want to get out of our lane and start commenting on legislation, but I believe that just listening to the concerns that people have voiced and the vibe that I get from people who are concerned about this legislation, I think it is within our purview to say it will be difficult to craft a rule that seems to comply with the legislation that will make people want to become certified. Because I don't know a mediator yet who has looked over this, who has thought that this is something that will benefit the mediation process and will benefit the people who are part of the mediation process.
Thank you. Mr. Yamchan.
Thank you. Even though there's a state bar policy which we respect and observe, there's nothing that prevents the members of this working group from contacting your legislatures, nor is there anything that prevents you from educating your peers through your county bar or other organization of neutrals. And we all have our beliefs, and we can put our money where our mouths are. That's all I have to say.
Thank you, Mr. Pileski. Mr. Dinkin?
Yes, I'm fully in favor of doing taking the straw poll. I have been following this issue along with Mr. Kelly for many, many years, and know this is something that is of great importance that we've fought for decades. And I think anything that we can do, at least to have a voice as a working group, at the minimum through a straw poll, I think we should move forward with that.
Anyone else?
I see Mr. Pileski's hand up.
Oh, Mr. Pileski?
I agree that the statute as written or proposed is overbroad and has problems. I know that the author would like to reach some compromise, so I don't think this is intended to be the final version. And I believe they're trying to set up a meeting to discuss that with interested stakeholders for Friday. And I think there's a lot of fixes that can be made, and hopefully they will. So whether we need a straw poll on the statute as it stands now or not, regardless, I think there's going to be a meeting to try to address many of these concerns because it is way overbroad.
Anyone else? Mr. Kelly has asked if we would take a straw poll. I can ask Mr. Kelly if he'll restate what the straw poll is on so that everybody is clear. And if you prefer not to do that, that will be the question. Mr. Kelly, could you please tell us what the poll will be on?
I would like to move that, and if there's a second, then I think it's an official motion, but I'm not sure about if it's a motion to have a straw poll. I think that's a legitimate motion. That would be that if SB 574 passes in its current form, that would be a significant detriment to the certification program. That's what I'm asking a straw poll for.
All right.
Thank you.
Thank you. Is there okay, Miss Hodgson?
I just want to clarify the purpose of the straw poll. If advocating regarding legislation is outside of this working group's purview, what is the goal or the intended goal behind the straw poll? I apologize if I missed that.
That's
Would you
okay.
like me to respond to that, Madam Chair?
Yes, I would, please.
My understanding of advocacy is actually contacting a legislator or policymaker and saying, we want you to pass this or not pass this or amend it. And I don't believe a straw poll about whether we think this will affect the certification program is advocacy. I think it's simply information, and it'll give whoever wants to watch this, it is public record, some idea of what the opinions are of those of us who've been selected for the past year to work on the certification program. I hope that clarifies it.
Thank you.
Okay. All right, so Mr. Kelly has made a motion for a straw poll, and he has stated the grounds. Is there a second?
I second.
And that was
Dinkin.
that? Oh,
Steve
Mr.
Dinkin.
Yes. All right.
Can someone put up the actual
I don't know. Do we need to call I'm sorry?
It's a straw poll. It's a straw poll, so it's not going to be reflected in the minutes.
I can just have a show of hands?
Yeah,
then?
yes, like we've done before.
Okay. All right.
And just in case anyone's confused still, it's simply how many people in this working group think that SB 574, if it's enacted in its current form, would be a significant detriment to the certification program.
Can you put up the current form so we can just
of the legislation?
Yeah, the language. There's been a lot of stuff floating around. If we're gonna,
Yeah,
am I allowed to share my screen?
so let me have Alan share it. It's not a posted agenda material, so typically we are not supposed to. So just for those of you watching who are not in this meeting, it is something that's accessible through the legislature. You can essentially search SB 574 and you would be able to access it in that manner on the current version of the bill.
Okay, thank you, Erica. Doherty. All right, so Mr. Weiner, if you don't mind sharing your screen.
There's a lot of fine print here, which I hope you're seeing. It is, I believe, Mr. Kelly referred to paragraph B, how this would 6173B would be amended. And so that is all of this. I don't know, it's a lot to see on screen.
If I might refine the motion then for a straw poll, it would be if the legislation is enacted with the paragraph B2B, which if you can highlight that and anyone wants to read it on screen would have it.
Sorry.
That was
Make
it.
it larger and it disappeared.
Mr. Kelly, while we're looking at this, I just wanted to share, this is Jenna Ellis, that the phrasing of your straw poll is throwing me off a little. The would be a significant detriment to certification. I wonder if you'd be amenable to phrasing it more along the lines of would result in less practitioners and providers choosing, something that's a little bit more, I don't know.
I accept that as a friendly amendment. I think that's an excellent refinement. Thank you. Does Mr. Dinkin accept that as well?
Yes.
Are you able to see the paragraph capital B to capital B?
Yes.
Thank you.
And I'll just point out that the significant part of that is that it says the word shall. Any certified dispute resolution firm, provider, or practitioner, and licensees of the state bar shall, that's the word, provide to the state bar or its agents all requested information, records, and communications. That's quite significant language.
All right.
It puts a legal responsibility onto certified mediators and any lawyer participating in a mediation conducted by a certified mediator to turn over mediation communications that up until this passes, if it does, have been inadmissible and not subject to discovery in any later non-criminal proceeding where California law applies.
Any other comments or questions? All right. Mr. Kelly this is just a vote, a show of hands on who would like to take a straw poll. That's what this is. So may I see a show of hands of those who would like to participate in a straw poll? Okay, I see Ms. Coulter. I see Mr. Dinkin, Mr. Yamshan, Mr. Kelly, Mr. Tuckman, Ms. Kopakin. Judge Lucky, I think I said Ms. Coulter. Is that a majority of the group?
Well, hold on.
I believe Mr. Higuchi has his hand up. I think Mr. Polewski, Mr. Welch.
Appears to be a majority, Judge Pichon.
Okay, thank you.
People who raise their hand.
All right, so we will now have a straw poll. Again, another show of hands on who would support the recommendation as stated by Mr. Kelly and modified by Ms. Ellis. Yes. Okay. Does everybody understand? All right. Then we're ready for another show of hands who would like to support the statement made by Mr. Kelly as modified by Ms. Ellis. A show of hands, please. See, Ms. Kopakin, Judge Lucky, Ms. Lowe, Dr. Getz, Ms. Hodson, Ms. Coulter, Mr. Tuckman, Mr. Welch. Did I get everybody?
Yamshan and Getz are both hands up.
Okay, I have Getz and Mr. Yamshan. Did I miss anybody else?
Higuchi
Mr.
and
Tuckman, Welch. Okay.
Madam Chair, I think it's unanimous as I see the screen.
It's everybody other than staff and yourself, Judge Pichon.
Okay, all right, so wait. Okay.
Madam Chair, you get a vote as well if you'd like to.
I was looking for raise your hand. I don't usually raise my hand, but let's see, where is it?
Okay. So it's everyone has raised their hand.
Okay. All right, good. Now, that we've done that, Mr. Kelly, is there anything else you would like to discuss before we go through the appendix?
No, ma'am. Thank you very much for your courtesy and for the support of the group.
You're welcome. Okay, now we'll move on to Appendix D. Appendix D has a lot. Ms. Copagan.
Thank you, Judge Pichon. Before we moved on from the subject Mr. Kelly raised, there was one other thing that I wanted to point out in terms of, I think there's a little bit a lack of clarity in that proposed rule that also gives me some concern in that it also said, it gave a laundry list of the statutes that we all understand protect mediation confidentiality at this time, but it also said or other law. And so I have some concern on the notice factor that we've talked about for our program, and that's just another reason that I voted or straw polled in favor of that. So I think that's worth us considering as the it is squarely within our purview to talk about notice from what we're doing and what certified practitioners and firms would be, what they're signing on to. Thank you.
Oh, okay, Ms. Copagan. And so is there any change in the process that I had proposed?
I don't think so. I just wanted to lift that up and that it's not just that we don't agree with a proposed legislation. I'm not trying to affect the legislation. I also think from a process perspective for us, I think we need to be concerned with whether we're giving adequate notice to those who might become certified. And that's troubling, I think, on another level.
Okay, all right, I see. All right. Now, for Appendix D, for standards 1 through 5, I'll be reading the comments to you. But for the remainder, 6 through 12, I'm going to be relying on staff due to the length of the actual comments, and they were pretty lengthy. Appendix D are the proposed ethical standards for state bar certified mediators. Overall, there were 74 narrative comments about the tentative recommendations in Appendix D, and they were submitted by 25 individuals and organizations. The first one standard is purpose and function, and there were no narrative comments. The second is application, and that's application to certified mediators and application to certified firms. C is inapplicability to judges, and D is inapplicability to settlement conferences. These are the comments. The mediator ethics standards would currently apply to ADR services conducted by an ADR practitioner, no matter the laws applicable to the underlying dispute or geographic location. The next one is I respectfully urge the working group to revise the proposed ADR certification framework. As drafted, it appears to extend beyond certifying ADR providers and toward ranking individual mediators. That may narrow party choice, burden solo and non-institutional practitioners, and privileged institutional affiliation over actual skill, experience, and community trust. Another is Section 2B. This is overly broad, applying to all mediators and all employees of a provider. This would be viable for small local firms, but application to large providers with a national and/or international scope would be problematic. Those are the comments. And please, if you have any other comments you want included in this discussion, please say it. So for standard 2, which is application, does the group wish to make any changes? Ms. Ellis?
I don't think anybody's surprised to hear from me on this, but I would recommend that we adjust the application scope to make clear that these standards apply to matters conducted in California or under California law.
Anyone else?
I support that change as Kelly.
Okay. Anyone else? Um, I'll ask for a show of hands. Would you like to make that change?
Mr. Tuckman has his hand up, I thought, for a comment, but maybe I'm wrong.
Mr. Tuckman?
Yeah,
I
and
didn't-
my head up hopefully too. Yeah, I'm in support of that change, certainly.
Oh, okay. Look at the hands. Okay. Um, let's see, Mr. Yamshan. So
I'm voting for it.
you're voting for it. Okay, so may I just have a show of hands of everyone who supports that recommendation by Ms. Ellis?
Majority of the hands are raised, Judge
Okay.
Bichon.
All right, so we will make that change. Now we need to insert it somewhere. Ms. Ellis, where would you like to see that change?
Oh, Judge Pichon, I was worried you were going to call on me for that.
Yes, I wouldn't want to answer that either.
Mr. Tuckman, I see your hand still raised if you have any suggestions. No.
Mr. Tuckman.
No, there's no easy place for it. You might have to add a letter.
Yeah, I would probably recommend adding a letter. But beyond that, I think it will take a minute to
Okay.
wordsmith.
Okay. Well,
Are you still seeing my screen? No, it says it
No.
stopped.
no.
While we're waiting, Judge Bichon, I do see Mr. Kelly's hand raised.
Yes, Mr. Kelly?
Thank you. The section that said it's not applicable to judicial officers while they're governed by the Code of Judicial Ethics.
Yes.
I read the response from a JAMS judge who was part of the LA scandal stories that set this whole thing off. And I thought I understood him to say, that's exactly what I was doing. That was the status that I had while the allegations were made about me. So I'd really like to understand if we're exempting judicial officers, that if I understood it right, were their actions were the ones that triggered all of this concern in the legislature. And I'm not making any judgments about whether they did or did not commit any malpractice or malfeasance of any kind, only that I'm interested in understanding what C actually means in terms of other judicial officers serving while they're governed by the Code of Judicial Ethics. If someone can clarify that for me and whether it does or does not include the people that were written about by the LA Times, I'd appreciate that. And I see Judge Lucky is ready to explain that to me clearly. Thank you.
Yes, Judge Lucky.
I don't know if I can give it an adequate explanation because I will tell you that other than reading about it a little bit, I did not dig into the specifics. But I think the key issue that I see is that in those situations, those and some of the things that I do, I am functioning in a quasi judicial function. That's everything from I have had family law and one employment case where I was a general reference judge. So I stood in the shoes of the court. My decisions were binding. I was indistinguishable from being a judge and needed to follow the code of judicial ethics when handling those cases. I do special references as a discovery referee where I enjoy certain judicial immunities. And those are distinct from arbitration. They are distinct from mediation. They're governed by a completely different statutory scheme. So I don't want to editorialize too much. This certification program does not seem to target what people cite as the genesis of this certification program, which was a scandal involving some other form of work by people who work at jams. And again, I have my own opinions on whether I feel those people were treated rightly or wrongly by the press, my colleagues, and I'm going to keep those to myself because I don't think that that's pertinent. But what I do think is pertinent is there is nothing in the statute that governs the type of work that jams neutrals do as quasi-judicial officers, or for that matter, any other provider or individual, because I do know individual providers of private judging services who are appointed under the CCP to serve as a judge for all purposes or as a special reference. So it's not just institutional providers who provide referee services as a special or a general reference.
Okay, thank you, Judge Lucky. Mr. Yamchan.
Thank you. Some counties, Sacramento County, for example, appoints lawyers as judge pro tems for a day to handle pretrial settlement conferences. And in that very limited jurisdiction, we do have judicial powers, including the ability to enter settlement agreements as orders. So C would seem to apply in those situations, and D specifically recognizes the pre-settlement conferences. So, excuse me, although a pro tem wouldn't be a formal judicial officer, we are judge for a day, so to speak. And I believe C should apply to the pro tems as well.
Thank you, Mr. Yamchan. Mr. Weiner?
Yes, thank you, Judge Bouchon. So hopefully you can see my highlighting here. C specifically says judicial officers when serving in a capacity in which they are governed by the Code of Judicial Ethics. And the Code of Judicial Ethics, I believe, is pretty specific about when it applies. You may know that, Judge Bouchon or Judge Lucky, better than I do offhand. D also talks about when conducting settlement conferences conducted under Rule 3.1380, and that's a rule that specifically covers mandatory settlement conferences. Also, as far as how these landed in these ethical standards, they were taken directly from Rules of Court 3.850 et sec, the ethical standards for mediators in court-connected mediation programs, which Section 6173 says the rules of ethical rules for certified mediators need to be, I believe the term is substantially similar to the ethical standards for mediators in the court-connected mediation programs. So I don't know that that really answers the problem or the question, but hopefully it provides context.
Thank you, Mr. Weiner. Let's see, Ms. Ellis has made a suggestion. It's in the chat box. And Ms. Ellis, would you just state it, please?
Sure, I can state it. So I propose we amend subsection A to split it into subsections and say that the rules apply when a mediator is certified and conducts mediations in California or mediations governed by California law, and B, after decertification with respect to all mediations and mediation activities in California or governed by California law that had been conducted while the mediator was certified.
All right, and would you also do that in subsection B? Split it into?
Oh, I suppose so. There's probably a cleaner way to do all of this, and I might just respectfully defer to staff or well, it depends on whether the plan is to vote on this today.
Yes, we'd like to. So, okay, why don't we, Ms. Ellis, what you said sounded good. So, but you said it very quickly. I'm sure it was very difficult for Mr. Weiner to get that down. So let's try it. Let's try and do it. We'll just take our time. And Mr. Weiner, if you don't mind, if you can make it just a little bigger. Thank you.
Yeah, so I've taken Miss Jenna Ellis's comment out of chat and copied it here. So
Okay.
hopefully, um, can you read that, Miss Ellis? And is that essentially your suggestion?
Yes.
So one question, if you will, after decertification, I don't know if your intent is that that only apply if certification is revoked by the state bar, which is sort of what decertification brings to me, or would you, if a mediator voluntarily becomes uncertified or lets their um, certification status expire, would you still want the second paragraph to apply?
I that paragraph, the gist of it was in the original language, so I maintained it, but to be
Yes, I see
honest,
that.
found it a bit confusing myself.
Can I make a friendly suggestion?
Yes.
I think instead of when, you may want to use to. And then I think just for parity, you may want to use a certified mediator who conducts mediation in California or mediations governed by California law. Just trying to align it with other language we've used in other rules.
I differ on all of this. No, we're
As Alan knows, this is my consistency is a thing that I'm very interested in.
So I just wonder, I wonder, we have 40 minutes left. I wonder if we're realistically going to get through all of Appendix D within that time, or whether it might make sense to get take the friendly amendments now, have staff work on them overnight and send them out to the working group for maybe a final vote tomorrow to see whether they reflect the intention.
Well, that's
Does that
only fair.
seem-
That's only fair, Mr. Weiner. We can, yes, we can leave that. Um, I'm thinking, I want to ask, first of all, Mr. Kelly, I know your hand's up, so go ahead.
Thank you. It's an issue that I've grappled with all through this, and I think this language covers it, but I just want to raise the point. What is a mediation conducted in California or governed by California law? I've done mediations where everybody else was in a different state and I was on the phone or Zoom, and I'm in California. Um, does this cover what we want covered is just the question I'm asking. Thank you.
Okay.
Does your confidentiality rule apply?
I
I
was
have
thinking the
written,
same thing. Yeah.
I have a written agreement that says that we're governed by California law in my engagement, but I suspect that a whole lot of people don't. And that's the only reason I bring this up. I think this is a good definition, but I'm not sure it covers everybody we want covered. That's all.
Okay. Well, let me ask Miss Ellis, does this state what you are suggesting?
Yes.
Okay. Mr. Kelly has given his position. He's okay with it, but he's not sure it accomplishes what we want. Is there anyone who is opposed to this language? Anyone else? Okay, I don't hear anything. So I think it's safe for staff to work on this overnight. Okay. Then we can move on.
No, excuse me. One thing that just struck me, reflecting on Ron's comments.
Yes.
Rather than having the disjunctive California or mediations, California and mediations to make it a two-pronged test, because I can't be the only one who's done multi-state mediations without any substantive or party contact with California.
And so you'd like for and conducts
California and mediations governed by California law.
and mediations.
Yes.
Okay.
So just for clarity to help staff draft this, you want both of those conditions to apply for the ethical standards to be applicable. You want both of those conditions, meaning the mediation is conducted in California and it's governed by California law. So if a certified mediator conducts a mediation in California that's governed by New York law, you would not want these standards to be applicable. Is that what you're saying?
Yeah, I've had mediations where I've had parties in 3 states and none of them are in California.
Okay, does this reflect?
Yeah, I think a different way to ask the question would be does Miss Ellis feel like they need to the physical presence matters, or if California law matters, or they both matter?
I want to just take a second to go back to what we ended up approving for the provider subgroup application, because I think Ms. Doherty, in a similar vein, I'm all about consistency, and that's why this came up for me. So let me see if I can find it quickly. I mean, and if the answer is that Mr. Yamshan's raising a really good point and we need to circle back, then I don't, yeah, I appreciate and respect that. So in the provider standards, at least the draft that I have up, we said that they applied when the certified provider, when it was involved in an ADR service conducted in California or governed by California laws, but the focus was on the ADR service being conducted in California, not the location of the mediator.
Is this consistent then, Ms. Ellis, of what you just read for provider?
What's written above refers to where the mediator is conducting the mediations from, rather than focusing on the ADR service. So it's close, but I wouldn't say it's exactly the same.
But is it satisfactory written this way? Is that what you are suggesting?
I would say that to the extent we're aiming for consistency with the ADR ethics standards that we recommended to send to the board, we use or instead of and in those. But and so sorry, Judge Bichon. I'm not certain what else to add at this time.
If I can just interject a thought here. I mean, part of the issue that the provider organization subgroup dealt with is you may have a multi-state provider organization who has practitioners in or outside of California. So I'm not sure it's exactly parallel or should be exactly parallel for practitioners and for provider organizations.
All right, Mr. Kelly.
I want to speak strongly in favor of the word or, because I think what we want is more expansive application. So if you're either conducting it in California or it's governed by California law, if I understand the intent. Thank you.
Okay. All right, so everybody will get a chance to sleep on this, but right now, is the wording satisfactory?
I look
Close.
forward to seeing Steph's wordsmithing.
They're not going to change, they're just going to make it grammatical and make sense, but they won't change what your request is. So,
Close. I can see Mr. Techman in New York handling mediations in California. These are modern times with modern communication capabilities. I'm just thinking of those admittedly rare cases where there's no contact with California, there's no situs of anything in California. Uh, California really has no interest in any outcome, yet the mediator could be in California.
all right. Mr. Polewski?
Just as a point of information, I'm not a mediator. What mediations are covered by California law other than the confidentiality provisions? Are there any others that actually define California law and its coverage?
So if I may, you could have that by agreement. So the parties in a real estate contract may have a mediation clause, and the contract may also say that the contract is governed by California law, but Mr. Kelly may have had a better example.
I agree. It may be stated in the arbitration agreement.
That's normally the substantive law, but okay. If you're good, I'm good.
Okay. All right. So unless there's an objection to this, we're going to go with this for overnight revision, but this is basically what it will say. Okay, very good. So we'll move on then to standard 3, which is definitions. And it has definitions of mediation, mediator, participant, party, program, certified firm. The narrative comments include current definition of a party does not capture nature of family law or other types of mediated matters. Another, we recommend clarifying that divorce proceedings, non-litigation matters, pre and post marital agreements, business contracts, etc., or pre-litigation matters are expressly included within the definition of party. As currently drafted, the definition focuses on claims being asserted, which may not fully capture the nature of family law and other types of mediated matters. The next is there's a difference between mediator and certified mediator. It should be clarified and the definition should reflect that. Any changes based on the comments that I've read to you and the comments that you've read that are more expansive than this? Mr. Kelly.
The commenter that talked about how the definition of party is referring to people who are asserting claims, I think is a very valid one from a lot of different standpoints, and certainly family. And I wonder whether it wouldn't make more sense to adopt the statutory definition of mediation in some form here. I'll leave that to staff, but I think it's a good point that people aren't necessarily asserting a claim against each other if they're trying to sort out whether they get divorced.
And where would that go?
Well, their comment was about where the language of asserting a claim or against whom a claim is being asserted. And I think the point of the commenter is a good one, that they want to expand it to mediations of a number of different kinds that don't necessarily involve a straightforward claim either way. Business partnerships that are trying to decide whether to break up, marital, there's a lot of people who have relationships of one kind, business, family, whatever, who are trying to sort through probate matters, for instance, where they haven't yet asserted a claim. They're just trying to sort out who gets what. I think it's a really important comment. That's all.
All right. Okay. So, Mr. Tuckman?
Yeah, I wonder if I do agree with this point. if the definition just ends after the word mediation. Party means any individual, entity, or group taking part in a mediation. Actually, the additional, I think maybe what we're trying to get at here, the additional language who has a direct interest in the subject of the mediation, but that actually is perhaps overly broad. There are a lot of people who say they've got an interest in the outcome of a particular case, and I don't know that that's necessarily what we're intending to get at here.
Okay, thank
Or
you.
or we look at, sorry, or there might be some other statutory definitions that maybe should be looked at, but I think you could solve the problem just with the period after mediation. Alan, I think I cut you off though.
Mr. Weiner?
Yeah, I think it's difficult to wordsmith this sentence without looking forward in the document and seeing what the mediator's obligations are under these ethical standards with respect to parties and with respect to participants as those terms are defined, because that's the reason why there's a difference in definition of party and participant. So some ethical obligations apply to parties only, as that term is, however that's going to be defined, and others apply to all participants. So I think we need to be careful about refining the definition here without looking at every place where it's used, where the defined term is used.
Okay, because 3C does give the definition of participant, and then D is party. Mr. Weiner?
I think yeah. I mean, I think again, if you're willing to come back to this, staff can prepare a list of the distinctions, what ethical obligations apply with respect to a party and what apply with respect to a participant. And we can bring that back to you for you to reconsider this definition. I hate to keep suggesting we bring things back to you, but I think it may be important for you to consider it in that light.
Okay. We can do that. All right, then for now, we'll pass on definitions, standard 3. The next is standard 4, voluntary participation and self-determination. The comments were where the rules require the mediator to inform the parties of certain things, clarify that this may be done orally or in writing. If it is done in writing, it should be included in the mediation or confidentiality agreements. The next is the current statutory and implementation structure
Judge Pichon, I think you're breaking up. Or is she breaking up for others?
Yes.
Yes.
Okay, I'm sorry.
Okay.
Okay, so the next one is the current statutory and implementation structure should be revised before it hardens into a statewide framework that narrows a party's choice, marginalizes solo and non-lawyer mediations, and increases costs for neutral and disputants, and shifts mediation away from self-determination toward institutional conformity. The next one is paragraph 4C, specifically obligates the mediator to refrain from coercing any party to make a decision. This is an unnecessary restatement of the obligation already included in paragraph 8B to assure procedural fairness in which each party is given an opportunity to make uncoerced decisions. And the last is, it is unnecessary to have to tell people that it is a voluntary process. Having to explain all of these things to participants is onerous and unnecessary. Would anyone like to make any changes to standard number 4, voluntary participation and self-determination? I don't see any hands. I think we're safe to move on. And the next one is number 5, standard 5, confidentiality. The comments were that were on point. I don't want to say on point because that's my judgment call. But one comment was the committee should include guidance on the use of AI and how it may breach confidentiality, privilege, etc. Another comment was should not have to explain confidentiality at the beginning of a mediation. I'm also concerned about breaching confidentiality if a complaint is filed. Some people can file claims with no basis. The other comment related to tiers, and then let's see, there was another comment. It was related to where the rules require the mediator to inform the parties of certain things at or before the outset of the first mediation session. They should clarify that this may be done orally or in writing. It's very similar to another comment that I read. Would anyone like to make any changes?
I see Mr. Kelly's hand.
Okay, Mr. Kelly?
So understanding that this is going to be controversial, and I understand that, the rules we're doing our best to craft do directly involve a mediator's obligation to advise the parties on confidentiality. And I'm not entirely clear how to draft this as a condition, but the intent is that if SB 574 becomes law substantially as currently drafted, then to what extent an ethical certified mediator will need to advise the parties that 30 years of consistent law and policy have significantly changed is the purpose of my stated intent to adopt required warning language as part of Appendix D, confidentiality B, informing parties of confidentiality. I think I've sent that to the committee. I would like to move that section, confidentiality B, informing participants of confidentiality, be amended to read, and I'll keep what's there now to start with. At or before the outset of the first mediation session, a mediator must provide the participants with a general explanation of the confidentiality of mediation proceedings, and then add the following, which shall include the following warning. Warning, I'm required to inform you that 30 years of California's mediation confidentiality protections have been reversed whenever you use State Bar certified mediators. Anything you say in mediation, your mediator and your attorney may now be required to repeat to the State Bar if any of the opposing parties later complains against your mediator. They may also have to turn over all confidential briefs, documents, texts, and emails created for the mediation and all mediation-related attorney-client communications. And I'm happy to put that language in the chat.
Mr. Kelly, is that the same as the language, exactly the same as the language that you had included in your email to the working group?
No, sir, it's not. It's modified a
If you
bit.
put it in the chat, that would help, because I was prepared with your email text, but if what you just read is different, I'll happily put that here so everybody can see it.
Let me see how I can put that in the chat.
Judge Pichon, if I may, just to address Mr. Kelly's question about how to do this procedurally, given that it's a pending bill, I can take that portion now, and then obviously people can discuss the substance of what's being proposed. as well. Historically, organizationally, what we've done when there's something that's pending or may not, if there's a contingency associated with it, that's essentially put into the resolution. So that would be something along the lines of once the, working group, if the working group aligns on language of this nature, what could happen is it could be adopted via a motion that would say, subject to, substantially similar language being enacted through SB 574 or something of that nature. So it is feasible to put those kind of caveats into what is ultimately proposed either today or at a future meeting.
Thank you, Ms. Doherty. Is my language visible now, Mr. Weiner?
Give me just a moment and I will get to that. Mr. Kelly, can you tell me whether I have correctly captured your changes to the original body so that I can just paste in your warning? I think you were leaving everything the same through the original part, but adding which shall include, and then adding the warning that you just put in chat.
Yes, sir. I believe you've captured my motion word for word. Thank you, sir.
Okay. Ms. Doherty, were you offering language also?
Not yet. I'd like the working group if you'll allow them and me to have some time to kind of talk through the warning language. I certainly have thoughts on it, but I'd like the working group to give their thoughts first.
Okay, all right. Would the working group like to comment on the language that has been suggested by Mr. Kelly?
Oops.
I don't see any hands.
Mr. Yamshawn's hands up.
Oh, okay. Mr. Yamshan?
Thank you. I'm not sure I'm going to support this. It does seem rather drastic, but if I do, I think, or if we approve it, I think we should add work product as well as communications, because certainly work product in preparation for mediation would be something the state bar could seek under the legislation.
Okay. Mr. Kelly, would you want that language included in your proposal?
Absolutely.
Okay.
But I don't know if my motion requires a second to be discussed. I would think so, and maybe no one's interested in seconding it.
Well, okay. I was trying to make sure I had everybody's comment before we got to a second, but that's fine. That is procedure. Does anyone want to second Mr. Kelly's proposal?
I'm not sure I'm going to vote for it, but I will second it because I think we should discuss it.
Okay, and I'm
Jill
sorry.
Kopeikin.
Oh, Ms. Kopeikin. Okay. All right, discussion. And I am cognizant of the time. It's 4:48. We will stop at 5. So if anyone would like to make comments now, we'll still take it up tomorrow. Okay, let me see. No hands.
Oh.
Mr. Pileski?
I think if the statute passes, we're going to have to include that in any description of confidentiality, but it seems premature to me. And I think the actual language here is a bit harsh. I do think it will be necessary to change everything you tell people if the language passes, but I'm hopeful that the language is going to be modified on Friday. So
Okay. All right, thank you. Let's see. Any other hands? Okay, there aren't any other. Unless someone has an objection, I'll ask Karen to take the roll.
Judge Bichon, I think staff would like to chance to weigh in on it to some extent if you'd allow it. I'll let Alan, I would defer to Alan.
Okay.
And I see Mr. Kelly has his hand up again.
Okay.
So yeah, I agree with the comments about it. It's hard to craft what a warning should be without knowing what the statute, if any, might be. So part of that can be addressed by Erica's suggestion to have sort of a contingent resolution if SB 574 passes. There should be a warning along such lines as the working group may come up with. With respect to the content of the working group of the language that Mr. Kelly is proposing, with all respect, I feel like it's not really a full disclosure such as should be made. I've kind of characterized it as more of an advocacy piece or a little bit of an advocacy piece rather than kind of a balanced explanation. For example, I don't think it mentions the important fact that the disclosures that might be required would occur in the context of first of all, would occur only if there's a complaint about the mediator. Second of all, would occur in the context of a confidential complaint procedure in which protections are, would be afforded by the bill, at least in its current language, in a couple of different ways, both general protections establishing the confidentiality and also specific protections prohibiting the state bar from disclosing under the Public Records Act. And I think that those would be important bits of information for somebody who wants to make an informed decision about whether to proceed with a mediation that is subject to this statute or not to. I feel like this as a bit of a scary message and not neutral and balanced, really. I think that if there's a requirement to make a disclosure about mediation and the exceptions about mediation confidentiality and the exceptions to mediation confidentiality, practitioners can craft an appropriate exception, or there could be safe harbor language, if you will, that presents a fuller and more neutral perspective on that. And for the most part, I think for all the other parts, there are a number of places in these ethical standards where it says the mediator needs to provide an explanation. And there's no other place where the standards prescribe a specific explanation, let alone an explanation that I think is not balanced and is scary.
Okay, so I'm going to call. Thank you, Mr. Wiener, Mr. Tuckman, and then Mr. Kelly. But I would like to say that if we were to pass this today and the language of the statute changes, and how are we going to take it back? I am just concerned that it is premature and that this would actually go to the board based on a statute that hasn't passed the legislature. Mr. Tuckman?
Yeah, I think the language does, it would require that every mediator sort of start off their mediation with a hand grenade, given the current proposed language, and maybe that's intentional. Again, I've got a question. And this relates to your comment, Judge Pichon, but it seems like between Cliff Polewski and Ron Kelly and members of the State Bar, probably there's some knowledge about what the current status and timeline is for the legislation, because we may have a real concern among the working group about this bill, but it sounds like there also is still a lot of work that's taking place, but it's a little vague to me. What really is the timing of the legislation and amendments, and what's happening on Friday? Is there a markup? Is there a hearing? Do we have any more information about that?
Well, if I had it, I would tell you, but I don't.
I do.
Let's see.
I received an
Was that
email.
Mr. Pulaski? Who was that, Mr. Pulaski?
Yeah.
Okay.
I received an email asking if I would participate in I guess it's a Zoom with members of the State Bar, Mr. Kelly, and some other interested parties to discuss the matter, because I was told that the author wanted to find some appropriate compromise. There was nothing other than a message that they realize that there's opposition, that it may need to be tweaks. I believe that there may have been some messages back and forth between Ron and staff trying to get there. And I think there's a good faith effort to sit down and try to address the real concerns about how overbroad this language is. I mean, this language actually applies not only to certified mediators, but to all lawyers or all mediators certified by the bar. This language needs to be trimmed considerably, and I think they're trying to figure out how best to do that, and still, provide a meaningful complaint process.
Okay, thank you for that, Mr. Pulaski. Mr. Kelly?
Thank you. I agree with everything that Mr. Weiner said. And I want to ask a question of staff and then would probably withdraw my motion. The question to staff is, aside from the fact that this is scary language, and I wouldn't want to start with this if I were a mediator, is there anything that you think in here inaccurately states the impact of SB 574 if it passes in its current form?
The question is directed to
staff. Mr. Weiner, Ms. Ellis, Ms. Doherty, is there anything in this proposed warning that inaccurately states, in your view, the impact of SB 574 if it's enacted and becomes law in its current form?
I'll start. I would say yes, in many ways. First of all, we've never had a state bar certified mediator program, and we've never had, outside of court connected mediation, an opportunity for an individual in a quasi-regulatory fashion to file a complaint against a mediator. So I think this is a new world for all of us that requires a new set of rules, so to speak. I, like Mr. Polewski, have, I'm not going to include Mr. Polewski in this. I have grave concerns about a public protection agency being unable to investigate a complaint that is made against a mediator because of mediation confidentiality. There is nothing that we would be able to do. I recognize that this is different from what has existed for a very long time as it relates to mediation confidentiality. But as one of the leaders of a public protection agency that is going to be charged with certifying that mediators, arbitrators, possibly, etc., are adhering to certain ethical requirements, I don't think we can do that unless there is an ability to investigate a complaint against one of those individuals against whom the complaint has been made. So I think I'm maybe not directly answering your question, Ron, Mr. Kelly, excuse me. But I do think that we do need a different way to operate in this new world that is going to have a an option to become quasi-regulated for the very first time in this space in California.
Okay, thank you. Ms. Doherty, Mr. Weiner?
Yes, thank you. To maybe more directly answer Mr. Kelly's question about it, whether there's anything inaccurate. I think inaccurate by omission, things that aren't said that are material to provide context to this. I also think inaccurate by overbreadth, in including things that really wouldn't typically be included in an explanation about confidentiality or the history of confidentiality law, for example. And I think inaccurate by way of likely application. So the idea that the state bar is going to say, turn over all confidential briefs, documents, text, emails, etc. And Mr. Yamshan would add in and work product protected materials. I just don't see that being the way that the state bar is going to investigate a complaint. There have been conversations, as Mr. Polewski alluded to, between staff and Mr. Kelly, and discussion about narrowing some of these. So I do think that as a whole, the message is inaccurate.
All right. Thank you, Mr. Weiner. Mr. Kelly?
Thank you. Just in response to Ms. Doherty, I want to put in some statistics. It's not actually the first time that the state bar has come up against this, because the state bar has jurisdiction over all attorneys, no matter what they're doing, whether they're water skiing or not, in the words of a former state bar president, Mr. Towery. And I was asked to do a presentation for all of the state bar investigators and trial counsel by the chief trial counsel's office a few years back. And I asked in preparation to that for the chief trial counsel to do a survey of all of the investigators and prosecutors and ask in how many cases in the past year has the existence of our current confidentiality laws been a substantial problem? And the answer was, in about 4 cases, some, and that's out of 17,000 complaints investigated by the state bar against attorneys. And the general answer in the seminar that I did, the workshop that I did, was we found another way to go after these people anyway. It didn't interfere with our investigations in any substantial way that influenced the public. So I just wanted to put in that statistic. This is not a new problem. These statutes have been in effect since 1998 and been the subject of 5 unanimous Supreme Court decisions upholding them. And the state bar has had the jurisdiction to investigate attorneys in mediations all of that time. And the statutes have not, in fact, at least according to the survey done by the chief trial counsel, provided any substantial problem with protecting the public. Thank you.
Okay.
And if I may, I would like to just say that I don't think these are the same thing. I think these are apples and oranges. I'm mindful of the time, and I don't know that we need to engage in a further back and forth debate on this. But I think that, to be continued at our next working group meeting, perhaps when we further discuss the proposed language on the screen.
Okay. So Mr. Kelly, you did say if you had your questions answered, consider a move. But if not, that's fine. Do you want a discussion of this particular warning to continue on to tomorrow?
In the interest of the working group trying to finish its work, I hereby withdraw my motion and appreciate the courtesy of the ability to discuss it.
Oh, Well, you're certainly welcome. We appreciate the time that and attention that you've given to this and the commitment that you have um, to mediations and that they're fair. So, all right. Um, then we'll start again tomorrow. Uh, we will continue on section. And in Appendix D, we'll pick up with some of the issues we passed earlier on it. And then we're still on number standard 5, confidentiality. Okay. I know it's tough. Thank you all so much. Thank you for hanging in here. And thank you for all of the attention and commitment that you've given to us. It is deeply appreciated. Our work is very important, as you know, and you are taking this very seriously. Thank you so much. So I will see you all again tomorrow
And
at 2 o'clock.
and you can acknowledge the tension too.
Uh, the tension. Oh, but that must have been Freudian, but because I didn't
Right.
mean that. But
I know.
I think the group's done extremely well. I appreciate how well and respectful everyone has been. So yeah, thank you so much. All right, I'll see you
You're
tomorrow.
welcome.
Thank you, Madam
Bye.
Chair.
Thank
Thanks,
you.
everyone.